Well, the confirmation of charges hearings at The Hague for the second batch of post-election violence suspects was going on at the International Criminal Court. Attorney General Professor Githu Muigai, who is the chief legal advisor to the government, and the Director of Public Prosecutions, Keriako Tobiko, were also at The Hague. Their mission: to convince the court's pretrial chamber 2 to issue the government with confidential evidence that could help in the investigations and prosecution of other perpetrators of the post-election violence. But according to Justice and Constitutional Affairs Minister Mutula Kilonzo, this was not necessary.
An investigation carried out by a non-Kenyan would be very difficult to be qualified as an investigation for a Kenyan court.
An estimated 6,000 people are said to have played a role in the perpetration of the violence. Ocampo only went for 6 individuals he deemed to bear the greatest responsibility for the violence. But Kilonzo says if the government wants to prosecute the rest, it has to conduct its own investigations.
The investigation of a case and the manner in which you collate the evidence, the manner in which you keep it in custody, is more fundamental than even the substance of the charge.
Ocampo says the request being made by Kenya lacked merit and that the government was yet to provide proof that it was conducting investigations, an allegation backed by the latest Annan-led mediation team report, which showed a majority of Kenyans do not think the government had the will to prosecute those suspected to have taken part in the chaos.
There is no known process of threatening witnesses in Kenya that we are not investigating and dealing with, and there is therefore no cause for alarm.
The pretrial chamber is yet to rule on Kenyans' request for the evidence. Thairu, Citizen Weekend.